Are you gonna be here tomorrow?
Tomorrow, no, not tomorrow. But on Angela Levine, that's just I just wanted to go on. She's in Florida. And
Okay.
if y'all just.
I got something for Little Langston.
Oh,
And, but I'll have it in the morning. Is this boring you?
I didn't say anything.
Yeah, no, you're sighing.
Yeah.
You sighing? Are you sighing?
Tired, right, yeah.
Yeah. Well, quit sighing. Do it outside, all right?
I don't want to judge.
Just informative.
I know this is bothering you, but let me just say,
I didn't
be
say
quiet,
anything.
sir. I will speak. See, the rules don't apply to you, do they? You've already been convicted of squeezing somebody's neck, assaulting a family member.
No.
You were convicted in 2006.
That wasn't a family, though. It was not.
I'm sorry, it's assault on a family member.
That was not related to James McCain.
Let me see the prior conviction, please. It's in the indictment. The grand jury is wrong. Looking at an adjudication of guilt in 85552, which is the allegation in paragraph 2 of this third-degree felony of assault on a family member that you're charged with, which alleges that in the 252nd district court next door, you were convicted of assault on a family member on February 24th, 2006 in 85552. Strangely enough, I'm looking at the judgment which says exactly that. You were placed on probation in that case on May 15th of 2002, 6 years deferred or unadjudicated probation. And the judge revoked that probation February 24th, 2006, exactly like this indictment states, and sentenced you to 3 years in prison. You're going to look me in the eye and say you weren't convicted of assault on a family member when this document says you were?
I was violated for technicality.
What is violated? Who violated you? You violated your probation.
Because I was behind in my probation fees. I never did receive a PRT.
Once again, were you finally convicted by that judge and was your probation revoked?
My probation was revoked.
And you were finally convicted?
Well, I don't even understand the system, so I felt like
you know what? It's real easy to figure out.
I didn't receive a federal.
Yeah, it's easy to figure out. But you came in and just earlier falsely told me that you were convicted, and there's the document that says you were.
But that case has nothing.
That has nothing to do with what?
What I'm in here for?
Yes, it does, because prior convictions enhance and elevate the punishment when you subsequently commit crimes. It's never in the past, sir.
Well, I was falsely accused because the guy.
You know what? You were convicted by law.
He was not my family member. He was not a family.
You were convicted by law.
Related in no way, shape, form, or fashion.
Are you finished? You were convicted. And when you look at me and say you weren't, you were lying to me. There's the document on the law that says you were. Which means this third-degree felony that you're charged with, which is similarly a crime against a family member. And you choked this person.
Yes.
When you choke somebody, there's only one reason: you're trying to kill.
That's not my family member.
When I finish speaking, you get a chance to speak, Mr. Interrupter. You see, the rules don't follow. The rules of decorum don't follow with you. You don't believe in the law right here,
No.
and you interrupt.
Excuse me, sir.
Sir,
Excuse me, sir.
you don't speak.
Okay.
until I'm through. She can't take both of us speaking. But you are just Mr. Rude from the beginning. You were rude from the beginning. You're defiant from the beginning. It's just like a child.
Yes, sir. I apologize.
It's just like a child. Let's start acting like adults. What this means is this new case of choking, squeezing somebody's neck, which is a third-degree felony if convicted. This prior conviction in 2006 bumps this up from a third-degree felony to a second-degree felony. So in spite of the fact you want to play it down and it's not important, it changes the punishment range in your case from a third-degree felony up to 10 years in prison to now you're looking up to 20 years in prison. Plus, you're not eligible for probation because you have a prior felony conviction. I consider that important and serious to deal with. But if that were the only thing, you got another third-degree felony charged in the stalking case in 25 CR 866. And then this 867 is the assault. So you're looking at, on this stalking case, this says it occurred on or about May 7th of 25. Is the state going to re-indict that to allege this prior conviction in 85552?
I don't know yet, Judge. Since the complainant in both of these cases is deceased, I know I can prove the assault family violence. I gotta look at the stalking to make sure. If I can, I probably will. Either that or give a notice of enhancement. That's all we need to do to enhance it.
Right now, this other case of stalking, you're facing a third-degree felony, up to 10 years in prison. So both of these, you're looking at up to 30 years in prison and you're not eligible for probation. John, what are we going to do today?
Your Honor, this is an issue that he's on a GPS monitor. One of the issues was to protect and keep the victim safe. However, the victim, like Mr. Laird said, is now deceased. So we are arguing and feel that it's not a GPS is not needed for that reason anymore. And so we can just return it back to normal conditions of bond and then keep moving forward with the case. But with no GPS, it's become financially burdensome to do that. And the need for it has now gone away.
We'll say.
As far as the complainant is concerned, yes, the need has gone away, but safety of the public is also a concern, and he does have a prior for committing this on another person. So I worry about anybody else he comes in contact with that we don't know where he is and can't prove that it's him right away. So
Your Honor, my counter to that is that when it was a victim, it was easy. It was good to have the GPS because we could show if he was going around her or where she was. But as far as a GPS protecting the public, it doesn't do anything for the public. I mean, he still has a right to go wherever he wants to go within limits, but we're not restricting him about being near somebody. We can't say stay away from everyone, and we can't control whether he commits another crime against another person. I mean, GPS monitor is not going to prevent that, do anything about that. When it was a victim in the case, it had its purpose, but now it doesn't have that purpose anymore.
but it does make a person know that they're being monitored to where they're at. So it keeps them at least from committing further crimes, knowing they've got a monitor on. It's up to the court.
Certainly is.
I'm just making my argument, but
Yeah, I just think that whether I mean, if he commits another crime, he knows he can get in trouble no matter what, whether GPS or not. If he walks into Dillard's and commits a crime, people are going to know he's in Dillard's. GPS is not going to do anything to stop that or to help that or to do anything with that.
GPS has its importance in certain kinds of cases. Yeah.
Like I said, Your Honor, I don't think it has a reason in this case now. It did before the victim passed away. It absolutely had a reason, but now it doesn't have a reason. And he hasn't missed court. I know that's another reason we use GPS to make sure people come to court. He's come to court.
Yeah. Okay. He sent a letter to me. Everybody gets a copy when back in September a year ago. Everybody gets a copy.
I have a copy of it, Jeff.
Okay. I've never ordered a GPS on circumstances like this. And I don't understand how, what's fair is fair. If I did it here in this case, I mean, we're really curious about the whereabouts of everybody that's on Raw, but that opens a door of
And I think it was originally ordered in this case because it was a stalking case and we wanted to make sure he wasn't on the victim. If I'm
how did the lady pass?
unrelated, it was.
There was a shooting at an apartment complex and she was an innocent bystander that got caught in the crossfire.
A sad thing, but it had nothing to do with this case.
Kind of like last case, last trial.
Yeah.
But yeah, I don't see what GPS device is necessary
Not now.
under this circumstance. But you do have conditions of bond, which are
Oh, sure. Absolutely.
normal and customary for everybody, like don't commit another crime. Because that'll get you.
Yeah.
Right now, you're looking at something that's serious enough. You don't need to add to it. But okay. The next thing is, these are indictments a year ago. So what are we going to do?
I believe it was set for and already set towards the trial's office.
Hey, is this set for trial already? The DA's office?
Yes, sir.
When is the docket, please?
I'm
I don't know when the date is, but I know it was set for trial already.
Are y'all able to recover that video? Or is that one?
Yeah, we'll be able to recover by the time we get trial. It's easy.
Okay.
It's not that big a deal.
So set for trial.
Seems necessary now.
August, right?
Yeah.
August, okay, all right. Get a resetting there. That's what we're gonna do.